In this vlog today, I want to talk about sentencing and how you should prepare for it. You can be sentenced in the Magistrates Court, the District Court, or the Supreme Court. And a sentencing can arise as a result of you saying, well, I did it and I'm prepared to be sentenced, or as a result of being found guilty in a jury trial, by a judge sitting alone, or in the Magistrates Court. A sentencing exercise is to show the court the person you really are. The prosecution, for their side of things, will want to show you in your worst light, and the defence will want to show you in your best light. I always start with the client who comes into my office and says, I want to plead guilty to this charge. The first thing we do is we take the statement of material facts and we go through it in detail with you. We've got to make sure and we've got to be satisfied that you understand the charge and you understand the facts that gave rise to that charge. If you disagree with any of the facts, and some of those facts are quite material, then it may have to go off for what we call a trial of the issues, which is a different process altogether and maybe the subject down the track of another vlog. But right now, let's assume that you have read the statement of material facts, you've been through it with us as your lawyers, and you agree with everything that's said about you. We then have to prepare you for the sentencing process. That will involve you perhaps doing a pre-sentence report where you must be open, honest, and give your answers with great candour. In other words, don't make things up. Don't diminish or minimise your offending. Just speak the truth. You may want to get references from people that you know. The best, of course, are those from an employer or an organisation that knows you, that you have worked for perhaps. But in those references, the referee has to state that they know the charge and they know about you and they're prepared to speak about you. Then you'll go through a series of conferences with your lawyer, whether it be us or another law firm. And during those conferences, we will take detailed instructions as to why you offended, what motivated you to offend, what you hope to gain out of it, and ultimately what your prospects are, what you intend doing in the future after you've been sentenced. Now, of course, depending on the seriousness of the charge, of the offence, it will depend on what you will receive from the court. For the more serious offences, an immediate term of imprisonment cannot be ruled out. For less serious offences, but up there with the most serious, you may be able to obtain a suspended term of imprisonment. And anything less than that would be an intensive supervision order or a community-based order. What you get in terms of a sentence from the court will be determined on the basis of the charge that you've pleaded guilty to and what the court has handed out in the past to other persons charged of the same offence in similar circumstances. The last step in the sentencing process and preparation for is to ensure that on the day you're ready to be sentenced. What you wear in court is entirely up to you, but it has to be sensible and it has to be respectful of the court. On the days leading up to sentencing, your lawyer would have told you what you can expect. If it is the Magistrates Court, you turn up to the court at the appointed time, you meet with your lawyer, and when you get called on, that's when the process starts. You may be asked to go down below into the holding cells and then be brought up to the dock via the inside stairwells and lift structures. Alternatively, security will advise you to wait for your lawyer and you can proceed to the court. So the sentencing process can take anywhere between 30 minutes to an hour or 2 hours. In the preparation for sentencing, I may write a submission and provide that to the court and the DPP if it's in the Supreme Court or the District Court. In the Magistrates Court, there's less requirement for written submissions and more of the time is spent, as we say, on your feet, trying to persuade a magistrate to come to a sentence that is reasonable in all the circumstances and does justice to the level of your offending. The Supreme Court submissions take place well before the sentencing date and are often involved and legally complex. But at the end of the day, it's always in your interests for your lawyer to be able to express on paper both the laws that apply and how those laws apply to the facts as you've agreed to in, for example, the statement of material facts or the indictment. I must point out that if you are charged with an offence where an immediate term of imprisonment is an inevitability, we get that out of the way the first meeting we have with you. Like I say to clients, let's get the elephant out of the room. If you're convicted on your plea of guilty of this, then you will go to prison. It's always good to hear a judge coming to the conclusion that an immediate term of imprisonment is warranted, but on the facts, we'll suspend it. We can't tell you that at the beginning. We can't say with any certainty whether something ordinarily that does result in imprisonment will be suspended. We certainly do have cases that up our sleeve, which we can refer to, where the sentencing dispositions have been anything but an immediate term of imprisonment or a suspended term of imprisonment. That is those cases that result in an intensive supervision order or a community-based order. But ultimately, the sentencing process and the preparation for sentencing is something we do very carefully with our clients every step of the way.